Good afternoon. I'll wait for the chairs to turn. I can. Can you hear?
It's like a basketball court.
Good afternoon. Welcome. I'm Gary Jenkins, the faculty director and the co-founder of the program on law and leadership. And it's my great pleasure to welcome all of you to our featured speaker series event. First off, let me say that if you're not already enjoying lunch, please begin. Part of our tradition at these events is we eat while we talk, so feel free to enjoy your lunch. A brief word about the program on law and leadership. It is a dynamic, multifaceted leadership development program that combines guest speakers, skills workshops, courses, mentoring programs, and scholarships, all designed to help law students and lawyers think critically about leadership and empower them to develop and reflect on their own personal leadership capacities. It's not only the nation's oldest, but it also offers among the richest leadership development experiences in any top law school in scope and in impact, and it's something that we're really proud of. But you are here to hear from our guest today, the 112th Justice and the 4th woman to serve on the United States Supreme Court. She embodies what it means to be a lawyer leader. Simply put, Elena Kagan's career is the stuff of legends. After earning degrees from Princeton, Oxford, and Harvard Law School in her 20s, she clerked for 2 iconic judges, Judge Abner Mikva of the U.S. Court of Appeals for the D.C. Circuit, and Justice Thurgood Marshall of the U.S. Supreme Court. Then, in her 30s, after practicing law in Washington, D.C., and becoming a beloved law professor at the University of Chicago, she joined the White House staff, starting as an associate counsel for President Bill Clinton, rising to become a senior policy wonk as deputy director and president of the President's Domestic Policy Council. And then after her government service in her 40s, she returned to conquer academia, teaching at her alma mater, where she went from visiting professor to tenured professor to dean of the Harvard Law School in just 4 years. And then in her 6 years as dean, she exercised leadership never before seen in Cambridge, Massachusetts. Okay? She united a notoriously fractured faculty. She raised a record-breaking $476 million and reshaped the institution along the way. Then one of her alums becomes President of the United States and calls her back to public service as the first woman to serve as United States Solicitor General until becoming the youngest member of the current court in 2010. On the court, she has quickly become known as an eloquent voice, but also a hip justice, in touch with technology and popular culture, if you've read any of her opinions. So she's going to be in conversation with our own Alan Michaels, the Edwin Cooperman Professor and the 17th Dean of the Ohio State University Moritz College of Law. These two share a lot in common, both native New Yorkers and avid New York Mets fans. And I understand these are good times to be a Mets fan. But they are also 2 deeply experienced lawyers, outstanding legal scholars, and accomplished problem solvers. So they've known each other for 30 years, and we're in for a great discussion about contemporary legal issues, the court, as well as leadership. So please join me in welcoming Justice Kagan and Dean Michaels.
Thank you, Gary. Welcome, Justice Kagan. This is the signature event for our program on law and leadership, and as a Supreme Court Justice, you've reached the pinnacle in law, but as Dean of the Harvard Law School and Solicitor General, you showed your gifts as a leader as well. So, law and leadership, you're our perfect guest. Thank you. Your mom...
It's great to be here.
Great to have you.
Yeah. No, it really is great to be here to celebrate Ohio State.
125th year of the law school.
I was stumbling because I couldn't exactly remember whether it was 125 or 100. But and to be at this great law school and this great program on leadership, and especially Alan to be here with you, because we do, as Gary said, we go back a long way, and the way we go back a long way is we were clerks together on the Supreme Court. This was in OT 87. You clerked for Justice Blackmun, and I clerked for Justice Marshall.
Yeah.
And we were always trooping down the hall to see each other. And it's really terrific to see you flourishing in this role, and it's a pleasure to be with you again.
Well, thank you. And we could just go back and forth like this for the whole hour. I will say OT 87, that's October term. The Supreme Court measures itself by the year that the term starts. So the first Monday in October is next Monday. We're especially lucky to have Justice Kagan. Her summer vacation is really over. OT 15 is about to begin, and so it's a great privilege. I will say on behalf of OT 87 clerks everywhere, we're especially proud that one of ours made it to the top. So thank you. Now, your mom was a public school teacher and your dad was a lawyer. Did you have a vision for a particular kind of legal career when you went to law school?
I didn't. I went to law school for all the wrong reasons. I was very conscious of this when I became a dean, and I would always talk to the admitted students, as I'm sure you do. And one of the things that I would always say is, you shouldn't. You should go to law school for the right reasons. You should go to law school because you really want to be there. You shouldn't go to law school just because you can't think of anything else to do. You shouldn't go to law school just because you want to keep your options open. And maybe like the second or third time I was doing this, I realized I went to law school because I couldn't think of anything else to do. And I went to law school because I wanted to keep my options open. And so I actually stopped giving this talk because I thought, it can all work out, even if you went to law school for the wrong reasons. I actually didn't know why I was going to law school. My father was a lawyer, and when I look at his career now, I can see how deeply meaningful it was and why he loved what he did. But at the time, it didn't strike me as something that I necessarily wanted to replicate. And it really was. I was a history major in college. For a while, I thought I was going to go on and get a history PhD. Then I did my senior thesis, and I thought, this is good, but I don't think I can live an entire life in the archives. And so I did go to law school, kind of not knowing quite what would come of it. But I loved law school. I mean, pretty much from the first day. I don't know how you were on this, but pretty much from the first day, I thought, oh, this is where I want to be. And for whatever sort of accidental reasons led me here, something went right. And I guess I loved it because it was a combination of two things for me. I mean, on the one hand, I thought it was just so intellectually challenging and stimulating. There's a large amount of law which is figuring out really difficult puzzles, and I liked that. I liked just just that sense of there's something really hard that I have to work my way through. Mm-hmm. But the other thing was that it did not seem at all like an academic enterprise to do that. It mattered in the end, getting the right answer and working your way through those really challenging and difficult assignments, because law mattered in the world. and it mattered to people across, in this country, across the world, in their daily lives. And so it meant something. And that's why I continue to love law, actually. I mean, that's why I love my job now, is on the one hand, it really is what one failed Supreme Court nominee once said it was, which is, it's an intellectual feast, in the words of Judge Bork.
I remember.
And on the other hand, it's much more than that. It matters in people's lives. And to have a job that combines those two things is to have an incredible job.
Well, you had the privilege of serving as a law clerk for Thurgood Marshall, whom you've aptly described as having done more to promote justice over the course of his legal career than any other lawyer in his lifetime. Now, Justice Marshall was also a famous raconteur. Late in his career, when you clerked for him, can you describe a lesson you learned from Justice Marshall during your clerkship, either from his words or from his actions, that'd be great for our students and alumni?
Well, I do think Justice Marshall was the greatest lawyer of the 20th century and one of the greatest lawyers of all time. I mean, if you measure what it means to be a great lawyer by how much justice did you promote in your lifetime, I think he's pretty much number one. And he was a great lawyer's lawyer as well. I mean, it was not an accident that he was the one that did all that really led the fight in the courts to eradicate Jim Crow, to bring about Brown v. Board and the cases after Brown v. Board that eliminated racial segregation from our society. Nobody, you're sitting there as a clerk, it's one of the all-time great experiences. As you know, it's a wonderful, heady kind of job to be a Supreme Court clerk for anybody. But then to be a Marshall clerk, where you realized that you were clerking for this completely iconic figure, a person who, had he never made it to the Supreme Court, would have gone down in all the history books as having been one of the principal people who accomplished one of the most dramatic changes for the good in our country. That was an incredible thing. And he, when I clerked for him, he was a great storyteller. And he was also at a stage of his life, I think, where he was a little bit looking back over the course of his life and reflecting on it. And that meant that we were treated to a kind of master class in a significant part of American history. And it wasn't just how much he had done, but he was also like just the best storyteller I've ever heard in my life. He was funny. He was kind of earthy. He stories that should have made you cry did make you cry, but also made you laugh. It was the most amazing thing to sit there and listen to him. And for these basically pretty privileged kids, to have heard about his life and where he came from and how he accomplished what he accomplished, it was just, I think, an eye-opener for me and for all of us in a thousand ways. And you can't hope to take from that oh, so this is how I should live my life, because you're never going to have his life. Right. And but the ideals that he thought were important, the values that he had, I think, were things that made a deep impression on me. Mm-hmm. And maybe his way of communicating with people did as well. The fact that he could talk to anybody about anything, mm-hmm. And make them feel comfortable, and he placed a high degree of importance on humor, and I think I took that away from him as well. It was a momentous year in my life.
So great ability to talk to anyone and make them feel comfortable, and humor. I'm interested, my next question's about leadership, and I'm interested to see if those emerge in your answer. So 3 years of private practice, 4 years on the law faculty at Chicago, 4 years at the Clinton White House, visiting professor at Harvard, suddenly permanent position, and a couple of years later, you were in your early 40s, they made you dean. And dean over what had been for some time a famously divided Harvard Law School faculty. So you have a reputation for success in working with different viewpoints, a reputation built and furthered by your great success as dean. Can you tell us something about your leadership principles or approach that allowed you to be successful in leading groups with such divergent viewpoints? One thing to lead a charge when everyone is on one side, but another when they won't talk to each other.
Yeah. Well, I'm not sure I have leadership principles or leadership approach in that kind of way. I don't think I've boiled it down to here are my 5 lessons on leadership. But I do know one thing, which is that you can't take an institution anywhere without people talking with each other, and without people talking with each other, including over things they disagree vehemently about, and without doing that in a way that expresses your confidence that they're acting in good faith just as much as you are. And I think that that's how progress is made. It's how progress is made at a law school. It's how progress is made in larger institutions. It's when people who do think different things come together and talk through problems and commit to listening to each other and commit to thinking through how something might feel to folks on the other side of an issue. And sometimes you can compromise, and I think that compromise is not a dirty word, and quite to the contrary. Mm-hmm. Occasionally you can't, but to commit to listening to each other, and to commit to never thinking that another person is acting in bad faith, even though that person is disagreeing with you, is I think a pretty crucial thing. And it turns out you might be wrong, right? Mm-hmm. That other person actually might have it right, and to make sure that you're always open to persuasion, in addition to trying to persuade others, is I think a pretty crucial part of that.
So those are some, you may not have listed them as principles, but there are some pretty solid principles in underlying that success. Now, you've had a number of important firsts. You were the first woman to serve as the dean of the Harvard Law School, and then the first woman in history to serve as Solicitor General of the United States. 2 wonderful, but it must be said, long male-dominated institutions. Did you think at all about handling your firstdom as you moved into these roles? And is there perhaps a story from that experience that might be an example of the difference diversity in leadership can make that you discovered as you did it?
Well, it's funny. I mean, I was the first in those 2 things, but I always felt as though it was a little bit of an accident that I was the first. I mean, I wasn't the first woman dean of a great law school. There had been many women deans of great law schools, and although I was the first Solicitor General, the Department of Justice had already had a woman attorney general and a deputy attorney general who was a woman. So I always felt that it was just a little bit fluky that I served in these sort of first roles, because I really came along at a time when most of the work in getting women to those first roles had been done. Mm-hmm. And I'm reminded of this every day on the court, because on the court there have been 4 women on the court, and we're sort of generationally divided. There was Justice O'Connor, of course, was the first, and then Justice Ginsburg, and then basically about 20 or 25 years later comes Justice Sotomayor and me. And between the first 2 and the second 2, everything changed for women. So that Justice Ginsburg and Justice O'Connor, you know, they graduated first in their class from these great law schools, and they went out and nobody would give them a job. Nobody would give them a clerkship. Law firms wouldn't give them a job. I mean, there was just nothing there. And these two remarkable women created these remarkable legal careers out of nothing, out of sort of maneuvering around and finding places where they could show their talents, but in none of the typical ways that their male colleagues did. And 20 or 25 years later, in part by virtue of the work that especially Justice Ginsburg did in changing the entire legal system for women, and in people talk about Justice Ginsburg as the third good marshal of the women's movement. 20 or 25 years later, it just wasn't true. I mean, when I came out of law school, I got plenty of clerkship offers, and all the law firms wanted me, and so forth. So it was, so it's not like all the problems had been solved, and it's not, but so much of the work had been done, and I really feel that, you know, I stand on the shoulders of people like Justice O'Connor and Justice Ginsburg, and my life was so much easier because of what they did. And by the time I came along, you know, it was true I was a first in a couple of things, but in a way there was sort of nothing unusual about it. And that's kind of a great testament to the way the world has changed and the legal profession has changed.
Well, fair and understood. I'm going to push you a little on Harvard more than the court, where Ginsburg was, and O'Connor, Justices Ginsburg and O'Connor, were great predecessors. But I can't imagine that a woman as the dean at Harvard Law School was different, and there was things that happened or that you, as the first, changed, or is anything, am I barking up the wrong tree?
You know, I mean, I have to tell you, I mean, there were lots of days when I didn't get what I want as dean, and lots of days where I sort of like went home and punched a wall because I had been frustrated in some way or other. So, you know, none of these jobs just like every day is a success story. But I actually never punched a wall and thought it would have been different if I weren't a woman. I guess I just never felt that. I thought my colleagues were incredibly generous to me. I never really felt as though people didn't take me seriously or for that reason. So I guess I'm going to say maybe you are barking up the wrong tree here.
So yeah, I don't give up. So what I'm going to do, I'm going to reach out to Martha Minow, the current dean of the Harvard Law School, and ask her, and she's going to tell me she's standing on the shoulders of Elena Kagan. So she'll tell me what barriers
I doubt
you
Martha
cleared.
needs to do that.
So you described in your answer about how you have some of the things you point to in success in leading factions to results. One of them was keeping yourself open to persuasion and the possibility that you might be wrong, and a crucial but can be a challenging skill for a leader. In each of your most recent roles, Dean, Solicitor General, and Justice, it can be easy to become entrenched in a viewpoint. How do you, I understand the value of it, how do you manage it? How do you stay open to the possibility that your initial, very smart, very experienced reaction might be wrong?
Well, I'm helped because I have these remarkably smart colleagues. So that there's really never a time in conference where I think I'm not going to learn from listening to what my colleagues have to say. And I think it would be a lot harder, actually, if you didn't respect so much the people around the table with you, and if you didn't think that they too have an enormous amount of experience, actually in this job a lot more than I have, and that they weren't like among the smartest people you had ever met. And that they too weren't incredibly prepared, and that they too didn't want with every fiber of their being to get it right. But I do think that about all my colleagues. And so I think that that's what makes it easier to do. But also just, I've been there for 5 years, and I think I'm not going to tell you a story of about a time that I changed in conference, because in some sense, because it happens all the time. That I sort of walk in and I know my pitch and I know what I think I'm going to say, and then I always speak last in conference. So I've had an opportunity to listen to 8 other people, and not infrequently, something that somebody says makes me kind of toss my notes away, and say something different from what I had thought. Whether it's just to say I agree with that person, or whether it's to try to find a third way, given what that person just said. So, it's a constant challenge, right? Because we're all people of strong opinions, and I know less than anybody else in that room. And you do come in sometimes thinking I am absolutely right. There's just no question about this. Every other argument is wrong for the following reasons. So it's something you have to work on to keep yourself open to listening and to really listening, not just kind of, sort of like, I kind of got the gist. I don't really have to pay attention anymore. But, and I'm sure I fail a lot of the time, right? But at least that's what I try to do.
So for the many students in the audience, respect for the person on the other side, and recalling sometimes when, I wasn't right about that, helps you do that in the moment.
Yeah.
That
was a more succinct way of saying it, yeah.
I'm known as the summarizing dean, so my colleagues will say, there he goes again. Justice Kagan, I love this question that I wrote. With your...
You've just upped the bar, know?
We'll see
It
if I can handle it.
better be good, Alan.
It's a good one. Tell me if you've had this one. So, Justice Kagan.
This shouldn't be one where I say, I don't know what you're talking about,
It
Alan.
better not be, no. Help me out, old friend. With your rocket-fueled rise through our profession...
I like the rocket-fueled rise.
Thank you,
yeah.
see? She's a great writer. With your rocket-fueled rise through our profession, you've had many moments that would certainly have made me gulp at a minimum. Congratulations, you're in your 20s, and you're going to help Justice Marshall draft Supreme Court opinions. Here, take the helm of Harvard Law School, and by the way, this ship's in some pretty choppy waters. Congratulations, Madam Solicitor General, as the new boss of the entire appellate docket for the United States of America. Will you please start by defending our campaign finance laws before a patently hostile Supreme Court in the first appellate argument of your career? So my question
Sounds
is...
like pretty scary stuff.
Yeah. What was
I don't even
your...
know how I got up here.
Yeah. What was your scariest professional moment, and how do you coach yourself to rise to the occasion in those crucial but frankly scary moments?
Well, I'll take your last one. I think that was truly my scariest moment. When, as you say, when I became Solicitor General, I had never done a Supreme Court argument. I had actually never done an appellate court argument. And I really did think that they had the wrong person for the job. And I say this truly honestly. I knew that the president was looking at me for a number of positions. I did not know that he was looking at me for this position, and meaning the SG's position. And when I got a call saying, we'd like to look at you for the Solicitor General's position, really, truly, I said on the phone, that's the wrong job for me. You should call somebody else, because that's not what I do. And they said, no, we're really confident that you can do this, and you're the person we want. And so I sort of went with it, I got vetted by them, and as I thought about the job, I thought, okay, maybe I can do this. Maybe this is not the craziest thing I had ever heard. And then I got to the court, and by the time the Senate confirmed me, it was already towards the end of the round of arguments for the year. So I didn't have an argument that, because I basically was confirmed in March, and arguments end in April. So over the summer, the last day of the term, the court decided to rehear arguments in the Citizens United case, turning what had been thought of as a pretty small campaign finance case into a huge campaign finance case. And it had done that by putting out an order saying, we want to rehear this case and we want to reconsider 2 prior precedents. And it was the writing was pretty clear on the wall that when they say they want to reconsider 2 prior precedents, it means that they're pretty close to reversing 2 prior precedents, and that the government's position is going down, and so too the congressional statute that the government had been defending. And that was my first assignment, which I had to do in a special session of the court in September. And it was scary. I mean, I had never been up there. I had never been before an appellate panel. And it was definitely the most nervous-making moment of my life. So what did I do? I prepared really super hard. I mean, when you have like scary moments, they're always made a little bit less scary, and you're being able to, is by working hard. And I think that's true for most scary moments. You're scared of something, work hard at it.
So avoiding it, and that's not the
that's
not the
like
approach.
not
Tomorrow.
Yeah, not a good strategy, I think. So I worked really hard, and then the other thing that I did, which I think is also like when I look back on it, I think I did the 2 right things. I worked really hard, and I talked to a lot of people, and I was really lucky because the Solicitor General's office is an office with such deep experience about how to argue to the court. And it's an office with an extraordinary number of extraordinarily generous people who really wanted to help me do this well. Mm-hmm. And so I talked to people endlessly, both about the content of the case, the substance of what I would be doing, but also about, how do you argue to the Supreme Court? And I did more than my share of moot courts, and I put a lot of people in the office through a lot of kind of informal mooting, and tried to listen to what they had to say about and so I get up there, and this is a long story now, but
it's good.
So the day before I had to go to the day before the argument, I had to go to the court for Justice Sotomayor's investiture. It was the day before the first argument. And the Attorney General and I went up together, and they put us in the clerk's office while they were just getting ready for the whole thing. And the clerk of the court hands me this stack of papers, and he says, this is what's going to be on the desk of every Supreme Court justice when you go up to the court tomorrow, all right? And what it is that every time that we go out onto the bench, we have papers that tell us about each lawyer. And the papers, they start off by saying, like, you're a member of, it's your Supreme Court bar admission and things like that. And then there's a list of all the cases you've argued, all right? And he gave me this stack of paper, and there were 4 lawyers arguing that day. And one was Ted Olson, and I'm making up the numbers here, but he's probably done about 75 cases. So you just kept on flipping pages, like all the cases that he had argued, right? And then one was Seth Waxman, and he's probably done around the same number of cases. And I'm just like flipping pages and flipping pages. And then the next was Floyd Abrams, and he had done fewer, but probably 20 cases, and one was Elena Kagan, and there was like nothing there. and I said to the clerk, are you trying to psych me out? I mean, because you couldn't do a better thing if you were trying to psych me out. He was like, no, I didn't. Anyway, I felt a little bit psyched out. So the next day, I got to the court, and I'm sitting at the table, And my heart is just racing. I mean, racing. My heart has never beaten as fast as it did that day. And I'm thinking, I'm just like so head up, I'm not even listening to people. I can't even listen to people. And I was getting worried about that in addition to being worried about everything else. And finally, I stood up at the podium and I had, prepared like the first 3 or 4 or 5 sentences that I was going to say, and I had basically committed those to memory. And I said the first sentence, literally just the first sentence, and Justice Scalia leaned over the bench, and he said, "No, no, 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 no." And it was actually the best thing that could ever have happened to me, because he just sort of like interrupted me, and he said, "No, no," and then he said whatever it was that he thought why he thought it was so wrong, my first sentence, but then I just sort of had to engage with him, and as soon as I engaged with him, everything was fine, and I realized after that exchange, and Justice Scalia can be a very aggressive questioner, but he's also an extremely good listener. He actually does, he asks hard, tough questions that really come at you sometimes, but he also gives you a chance to answer them. And during the course of that exchange, which went back and forth a couple of times, I thought, oh my, look at that, sentences are coming out of my mouth. And it all went fine. So I didn't win the case. But then again, I actually did not expect to win the case. I mean, the one saving grace of the summer and of how nervous-making this whole experience was, the one saving grace was people would say, you don't really expect that the court is going, the court had made, the writing really was on the wall, so I didn't really have a sense that I could win it or lose it that day. Maybe that's wrong. Maybe if I had done something differently, I would have won the case, but I doubt it. And anyway, but it was sort of a trial by fire. And after that, everything in the Solicitor General's office was pretty easy. It was not an all that eventful term, actually, except for that case. So it was smooth sailing after that.
A scary moment. Wow. Yeah, my heart's pounding just hearing you tell it. But the SG, of course, as you know, is sometimes called the 10th Justice, and the Solicitor General participates in a majority of the Supreme Court's cases, either as a party or as an amicus. And I think you've described the transition from SG to justice as the best job to prepare you, and as a comfortable one. You're moving from one side of the podium, as you put it, to the other. But at the same time as SG, you represent the interest of the United States. So you're urging the position that's best for the United States government whenever that can be argued in good faith. Then as justice, you represent the interest of, well, what? How would you describe that? And what is that transition from the government as a client to where you are now?
Yeah, well, I think a lot of legal careers are a matter of putting on different hats and performing different roles. And I think actually the best legal careers are like that. I mean, maybe this is, some people, they do a job for their entire lives and they do the same job and they're in the same role. And if that's what makes you happy, great, fine. But, a few questions ago, you actually went through a bunch of the things I had done. You were 4 years at this, and 4 years at that, and 4 years at this.
Your rocket-fueled rise.
I guess it sort of sounds like I just can't keep a job. But in fact, I think I've wanted to do a lot of different things in my legal career, and it's one of the great things about a legal career that people do have those kinds of choices. Boy, especially now, even more so, I think, that their life is long and you can do one thing for a little while and then do another thing and then do another thing. And as you change jobs, you know, you are putting on a different hat. You have a different role. You have different responsibilities. You have different people that you are responsible to. And I think one of the most important things for lawyers, you know, when they do change that role, I mean, you have to ask yourself, am I comfortable in this new role? Am I comfortable always representing the long-term interests of the United States? Am I comfortable, you know, doing X? Am I going to be comfortable being a dean and having to represent the institution and not my own personal viewpoints, which I may have to submerge in order to properly steward an institution? So you always have to ask yourself. But then once you've taken on that role, you know, you have to do it. And you can't be worried anymore about, like, you know, maybe I don't really personally agree with this or something like that. So it's in one sense, as you say, going from SG to being a judge is a very natural transition. In another sense, it's very different because your role is different. You are representing the government in the former role, and then you get to be a judge, and you don't have a client anymore, and you're just trying to get the law right in case after case after case, and that's a different kind of enterprise.
I'm hoping you'll stay in your current job for several decades.
Yes, no, I mean, I think, you know, my current job maybe has cured me of the wanderlust that's been attached to my lead, yeah.
But in that, you know, you don't have a client, as you say, but I guess a combined 9 years or so as Professor Kagan, now entering your 6th year as Justice Kagan. How would...
Those two things are very different, too. Like,
So,
people sometimes say, well, you wrote this. Right? It's like, I wrote this. I was a professor. You know, I was allowed to say whatever I wanted. Which is, you know, you ask, like, what are the great jobs in the Western world? I mean, being a professor is one of them, right? Because somebody pays you. What do they pay you for? They pay you to read what you want and to write what you want. That's pretty cool.
Yeah.
And
teach what you want.
And so you have this total freedom to write what you want. But so, you know, I used to write about administrative law. I used to write about constitutional law, and I've experienced moments during the time when I was a justice where issues that I wrote about, you know, appear in, you know, somewhat modified, but still, you know, there was a pretty clear relationship between this case that I was deciding and something that I had once said as a scholar, and when that happens, you know, everybody cites you. I've been cited my scholarship has been cited in more Supreme Court briefs over the last 5 years, I am sure by a factor of 100 than in the 5 years before that, right? Nobody ever really cited, you know, this stuff until, right?
Right.
And it's like, you said this. And mostly I've found these briefs to be utterly unpersuasive, you know? Because now I'm in a context, right, in which it's not just like I wake up out of the, you know, my bed and I sort of think a deep thought, right? You know, that I'm embedded in a set of decisions. You know, part of getting the law right in my current job is like reading a statute really seriously, reading a constitutional provision really seriously, reading all the decisions that we've had about a particular issue really seriously. And there are so many more constraints as a judge than there are as a law professor, and this is just like these two roles are just as different as like having a client and then not having a client. So that, too, seems to me like long ago and far away in terms of what my current job is. And very nice that I once thought that, but turns out that thinking it and doing it are not the same.
So how would Professor Kagan describe the judicial philosophy of Justice Kagan?
Professor Kagan would be very humble and say, it's too soon.
Oh, well played, Madam Justice. You've spoken about the importance of writing in legal education and to effective lawyering. And as a justice, she's been master of the bon mot. There was your opinion from last term about royalty payments on a Spider-Man toy, where you referred to the web of precedents, to the endless desire of children to do whatever a spider can, and dropped a footnote citing Stan Lee's Spider-Man dictum that with great power comes great responsibility.
In the text.
In the text.
Text.
Thank you. There was your wonderful conclusion in a case that badly fractured the court, in which you summed up the impact of a 4-1-4 decision as, quote, to be frank, who knows what, an admission or accusation adored by professors and lawyers everywhere. And there's my personal favorite from your first year on the court, your opinion in an otherwise dull case, quasi-innocently, in giving an example of the kind of thing the regulation at issue required trucking companies to post on placards. You offered the parenthetical explanation, "You've seen the type, how am I driving? Call 213-867-5309. Dayenu, for this alone, you will always be my hero. But seriously, we take, as you've learned on your visit, great pride in our program in legal writing and analysis, and you're known for opinions that are both accessible and incisive. So maybe here you have some principles to share with us about, for our students and alumni and faculty, about success in legal writing or things a young lawyer should bear in mind in trying to be good.
Well, there are lots of different ways to be good, and you have to work really hard at good writing. I mean, I work really hard at it, and I feel as though I can get better still, and want to work hard to get better still. Sometimes I like what I write, and sometimes I read decisions that I've written before, and sometimes I like them, and sometimes I don't really. And so I don't think I've discovered the magic elixir by any means. But also, and I'm, it's funny because I was talking to your faculty this morning, and somebody had this article, and it was Kagan's 6 Tips for Legal Writing. And it came from this interview that I had done with a man named Brian Garner, who's a specialist in legal writing. And we had talked for about an hour about writing issues. And somehow he managed to boil this down to 6 tips, which I'm sure I didn't give him in that form. And I said to the faculty, well, what are the 6 tips, just so I can write them down and do them, And I forget what they were. One of them was have fun. So I suppose that a couple of those examples that you gave were along the lines of have fun. But honestly, you should have fun in doses, not, and remembering who your audience is. Sometimes lawyers can't have as much fun as Supreme Court justices. Yeah. This is actually something where I think my experience in teaching actually has made a difference. Because the way I think about things when I sit down at my computer and write an opinion is the way I used to think about things when I sat down at my computer to prepare a class. And, because you're trying to do essentially the same thing. When you think about how to teach a class, you're thinking, so here are all these, very smart people, but they don't know a lot about the subject matter that I'm going to be talking about, right? So very smart, but basically uninformed. And here's the subject matter, which is, very often difficult, complicated, arcane, not intuitive. And how am I going to convey to these people, these smart but know-nothing people, what this is all about? And how am I going to convey it? And how am I going to convey it in a way that makes it stick? So I think of writing as being sticky or unsticky. The sticky writing is the kind of writing that you want. It's the kind of writing that stays with people. It's finding turns of phrase. It's finding ways of explaining things that people grab onto and don't let go. And that's what I try to think about when I write opinions. And sometimes it works well, and sometimes it works not so well. But at least that's what I'm trying to think about. I'm sort of imagining an audience out there full of smart people and interested people who don't necessarily know a lot about the subject matter that I'm going to be talking to them about, and to try to explain it as clearly as I can and in a way that will make people kind of grab onto it and remember it. And then, of course, also, and this is a little bit different than teaching a class, but to think about how to write persuasively. So, what's the story you tell that makes a person think, of course she's right? And that's usually a question of selection. It's like, what things do you think should be in there? What things don't have to be in there? What's the overall theory of the thing, the story you tell about why this decision, why this outcome is correct? And that is hard work. It takes a lot of thinking about a subject to be able to decide. You learn a lot of stuff, and then you basically have to go through the stuff and figure out what's the stuff that really matters, and what will persuade people that this is the right way to look at it. So that's at least what I try to do when I write.
Well, thank you. Now I have one more question, and then I think we'll have time for a couple of questions from the audience, and we have mics. So, Justice Kagan, what's going to happen in the Fisher case this term? I mean, you're recused, so no. Okay. Seriously, now, you've served 5 years as justice. Is there anything? And the answer to this may be no. She hasn't been prepped with this one, but is there anything you can...
Meaning you think I haven't prepped for the other ones?
Those are. This might be out of bounds, but is there anything you can feel reasonably comfortable that we court watchers should pay particular attention to as we await Supreme Court outcomes in general? You were a court watcher. You, as a Solicitor General, you were a professional court watcher. Before that, you were an amateur like me. But now that you're on the inside of there, is there anything you can say, look at this aspect of argument, or any such tips?
Yeah, I think I'm going to disappoint you on this one, too. Because, there is now such a court-watching industry that I think that they have covered the field in terms of watching what we do. And in fact, often I have the feeling sometimes when I read this stuff, it's like, really, that's what they're looking at? Like, it's like one of these things where when you write something and your readers are reading all kinds of things into something, and you think, I never thought about that for a second, right? Mm-hmm. So actually, I think sometimes people overanalyze what we do, and the idea that they have not figured out some particular analysis of what we do that, that I know, oh, this is the real thing, is, I think, very unlikely.
So, who jumped in first or what you had for breakfast, we'll just have to wait until July 1st, usually, to get the big outcomes. If someone wants to step up, we have mics here and here, and I can take a couple of questions. Mr. Warner.
Yes. Yesterday came out an article saying that 75% of the American public strongly believes that your argument in Citizens United was correct, and that the Supreme Court got it dead wrong, to the point that it's now becoming, very contentious on all these issues. And is there any mechanism short of an amendment of the Constitution that can be utilized for those people who feel that they would like to see some correction?
Yeah, so the days when I argued Citizens United were when I was back as Solicitor General.
Right.
And, there's nothing before the court and nothing that I want to comment on.
Fair enough. I have more. So, if you could go back and tell your law school self one thing, when you think about that, I drifted into law school, Elena Kagan. I know I don't want to be a historian, PhD. What would you tell yourself now, however many years down the road?
It'll all be good.
I like that. So, we have another question? Great.
Yeah,
Go ahead.
I have a question. So my question is, what is your favorite case and why?
Oh, that's hard. Favorite case, like?
Yeah, like your favorite opinion or your favorite case and why?
It's like asking, who's your favorite child? Maybe it's a little bit less dangerous to answer your question than to answer that question. But, I'm not sure I actually do have a favorite case. I've gotten assigned a wide variety of cases, and some of them are in glamour areas, and some of them really are not. I'm the junior justice. I get assigned my share of junior justice cases, as we call them, although the Chief Justice and others have also been remarkably generous to me and assigned me some, hotter stuff. But, I find, honestly, it's not necessarily the hot cases that are the most fun to work on. It's not necessarily the hot cases that are the most interesting to think about, and certainly it's not necessarily the hot cases that produce the opinions that you think are the best. So, if I gave you a case, you probably would have no idea what this case is. It's as likely to be something that nobody's ever heard of than something that somebody has. So I don't know if I had to pick among all my opinions. I guess one question is, it's a very different thing to write dissents than it is to write majorities. Dissents you can write much more for yourself. And you can be a little bit looser and freer in your style because you're not writing for the institution as a whole. But then again, in dissents, you've lost, so that deprives you of feeling as though it's really fun, So, I'm blathering because I'm really trying to think of what my favorite opinions are, and I would say from last year, I really enjoyed writing the Spider-Man opinion, because, and not because, a little bit because, there was all this Spider-Man stuff, and it was a way to, make a few jokes here and there. But because it was about a deadly serious issue, actually, which is the importance of stare decisis, and especially statutory stare decisis. And, and I realized that it was an opportunity for me to really think through something that was going to have a lot of significance to me over the course of my judicial career, a lot of relevance. And it was really interesting thinking through all those questions and thinking, I'm going to have to live with this opinion for a lot of years in my judicial life, and making sure I believed everything I was saying about stare decisis, such that I would be able to stick to the things I wrote in that opinion. Excuse me. I think that was a lot of fun.
So we'll do one question from this side.
Hello. So as the hip justice, I'm sure that you have seen...
Must be a low bar if I'm the hip justice.
Sure, low bar. But I'm sure that you have seen or may have heard of John Oliver's piece on cameras in the courtroom, and also represented the Supreme Court as very interesting dogs. And I was wondering if you had any insight, or maybe Professor Kagan would have more insight about cameras in the courtroom, since not a lot of Americans actually get to see oral argument at the Supreme Court.
Yeah. Can I talk about John Oliver first?
Absolutely. Yes.
It was a very funny piece. Yeah. And I think we all saw it. Yeah. And we were kind of comparing which dogs we were.
Sure. Was that your dog? Did you think you were that dog?
You know, I don't know why I was that dog.
I don't
I think we all decided that Justice Alito was the cutest dog. You know? He was like a cockerdoodle or something like that. So I think we all wanted to be Justice Alito's dog. But cameras in the courtroom, you know, really hard question. I can make arguments on both sides, and in the end, come down on the side of caution. So here there, you know, good reasons to have cameras in the courtroom. This is an important institution of our government, and people should be able to see and understand how it works. Now, in some significant degree, we do that, I think, more and better than any other institution without cameras. In other words, that there is nothing that we do, or almost nothing that we do. There are a couple of exceptions to this, but almost nothing that we do that we don't try to explain ourselves and say not just that we're doing it, but why we're doing it. And so I think, and that's the most important thing really, right, is here we're giving you a result, we're giving you an outcome, and now we're going to try to express as best we can why that is true, and we're also going to show you that there might have been dissent and controversy as to this outcome, and we're going to give you the other sides too. And so, you know, in a way, that's the most important thing that I mean, what do people need to know about us? They need to know why we reach the decisions that we reach, and we do that. But still, you know, I can understand, well, you know, people want to sort of, you know, see how it works up there. And in a way, I think, another reason for having them is, in a way, I think, people would like what they see. I mean, once they got used to us interrupting each other a bit and stuff like that. But I think when I was Solicitor General and I used to sit there all the time, I used to do one argument each month, and then I used to go to the court and watch all the other attorneys in my office do these arguments, and we participated in about 75% of the cases. So I was there a ton, and I had this sort of front row seat at the court. And I thought, this is an incredible institution, really. I mean, all these smart people up there, and they are really smart, and they are really prepared, and they are obviously trying to get things right, and they are talking with each other, they're talking to the attorneys, they're taking this seriously, they're engaged, they're active, they're questioning in exactly the ways that you would want a court to operate. And so I think in some ways, like oral argument and showing oral argument is a pretty good advertisement for what we do. But you know, there is a but. So here are the couple of reasons that I feel uneasy in the end about cameras in the courtroom. I mean, the first is that it sort of suggests that the whole thing is taking place in that hour in the courtroom. And that is pretty much the least important part of our decision-making process. So people would like focus on this hour as if that's where the decision was made, and that's where the critical things happened. And you know, when you ask how many cases are decided in oral argument, I mean, the answer isn't zero, but it's a lot closer to zero than it is to the number of arguments we hear, right? I mean, not all that many. I mean, argument is a time for you to flesh out some things on the margins. It's a time for you to talk to each other a little bit, which is what many of us use it for. But it's not where, for the most part, cases are won or lost. So in some ways, it's highlighting a part of the process that is of pretty low rank in terms of what people should care about, which is why we're reaching the decisions that we reach. And then again, and then also you have, you know, a little bit of fear that the very fact of cameras in the courtroom will change even what happens during that part of the process and in ways that are not to the good. And maybe it wouldn't. This is a little bit of a guessing game. But, you know, congressional hearings did not become better and more substantive when they put cameras in the courtroom. It just did not happen. And maybe you can say that we would be less inclined to go down that road. You know, we don't have constituencies, and we're not, I mean, that we would be less likely to play to the cameras. I think and hope that's true. But there's still a way in which observation changes the nature of an enterprise, and I think the enterprise works pretty well as is. It makes me cautious about changing it.
Thank you.
I know you've been patient, but we're past time, so I'm sorry, I'll try to mail Justice Kagan your question, but we're past time, and I have a couple of gifts for you, Justice Kagan. This is...
I've been reading about this.
Oh, yeah, so it just published, Showdown, Thurgood Marshall and the Supreme Court Nomination That Changed America. It's by Will Haygood, a Columbus native.
Oh, really?
Yes,
Huh?
and he'll be coming to speaking at the law school on October 22nd about this book, and it's about the nomination fight for Justice Marshall. And you do appear in the book, and here is a personally inscribed copy for you, Justice Kagan.
Thank you so much.
And then second...
I have been reading reviews and thinking, gosh, I want to read this book, so this is perfect.
Yeah, he has a book on the history of Columbus also, Will Haygood. He was best-selling author for The Butler, which became a major motion picture, great writer. Also, you're the 112th Justice, so now that you're a Buckeye,
You're not going to make me put this on, right?
I am not. We
it's
are
like
old
one
friends.
of these rules, like you never put on funny hats, and I think maybe you never put on.
Buckeye jersey.
Yeah.
Don't try it on in front of all of us, but you're holding it. That's good enough for us. Please join me in thanking Justice Kagan.